Okay, this week I have quite a few slides to try to get through, so I'm going to get started on time. And then if you have any questions, just be sure to drop those into the chat or unmute yourself, or you can raise your hand. So I want to make sure I'm recording audio. Okay. So I want you to take a second and look at the picture on the right-hand side, and then we'll look at the text just so I can provide a context for you. So most claims in the federal court system are not criminal justice related, so they have nothing to do with crime. So if you look at the blue bar on the screen, you'll see those are the criminal cases. Most of the claims that are in the federal court system are of two types. They're either constitutional, in other words, somebody's claiming that there was a violation of the Constitution, and those tend to be the gray bar, and then this darker color bar here, either prisoners thinking that they're not being treated correctly in violation of the Constitution, or there's some administrative agency that has violated somebody's constitutional rights, like Department of Justice, the IRS, right? There's some department within the federal government that has overstepped its powers. And so you can see those two things combined are about double criminal cases. Then the third category is the one I found students are the least familiar with, and there's a good reason why you don't know about this one. So this is other civil. It's because this includes cases where hundreds of thousands of dollars are involved. And so most cases in the federal court system, to be blunt, are about money. And so when you add these three things together, it's about 6 times than criminal cases. So criminal cases are very low on the priority list for the federal court system. Criminal court cases, on the other hand, in the state system, in the city system, right, are about even. Okay, so I just want to try to put that in perspective, so as we get started thinking about the federal court system and constitutional law, that we realize we're very rarely talking about criminal cases. We're mostly talking about other things. So I just want to kind of put that in perspective as we get going. So you had 3 cases, three readings this week that hopefully give you a historical, up to the modern perspective on what is exactly that courts do. So one of these cases you've probably heard of before, Marbury versus Madison. You were very likely taught this case incorrectly, so we're going to go over that in pretty concrete detail. You may have heard of the Federalist Papers, and this is the argument for why there needs to be federal courts. You were probably taught this concept also incorrectly, called separation of powers. We're going to talk about why that's wrong, and that's not what the Federalists said. And then we're going to end with talking about what it's like to be a clerk in the Supreme Court. And obviously all 3 of those readings talked about those things, so I'm going to highlight some of the things that came out in the reading, and then I'm going to give you kind of a broader contextual view. And this would be a building up of the video from last week. It's okay if you haven't watched it yet, but as I thought that you should know, or that you do know, you're learning them now. So what we're going to be doing is practicing a close read and bringing a larger context, something that lawyers do and something that scholars do. So the hard part, I think, is we have to try to go back in time. Right? We have to try to imagine what life was like in 1800 when Marbury versus Madison is being debated. So you want to start over here on this left-hand side with all these colors and understand this is the country at the time, right? So it's not the country that we know of today, and all of the West and Florida is owned by the Spanish. And at this time, they're fighting with the French over control of places like New Orleans, and even parts of Texas, which is also being fought over by the Spanish and indigenous cultures. And so, this is America at this time is not very big, right? It's basically just the East Coast. And then where you see the territories, those are American Indian areas under control, and the United States government is at war with those Indian groups. So are the Spanish, so are the French, and in some cases north, like the Northwest Territory, the British are still there. And so you kind of have to put this in perspective, right? That this is what's really going on. And just like today, there are two political parties that are vying for power. One is called the Republicans, which is kind of strange because that would be the Democratic Party today. And the other one is the Federalists, which would be the Republican Party today. Either way, one's conservative, the other one's liberal. So the Liberal Party is run by slaveholders, and they want to keep the laws liberal and debate and free speech and all this stuff because they want to keep arguing for the right to enslave Africans, and more so Mexicans and American Indians. On the other hand, you've got the Federalists, who some of them are anti-slavery, and they've been arguing for a unified federal law that bans slavery for good. And so you can see this is a big political argument about whether there should be a strong federal government, whether it should ban slavery, or whether individuals should have rights to own slaves. So the other thing to think about in that political context is, what does the court system look like? And so here's a great picture. This is what the courthouse would look like in each little town. They're very small, they're very quaint. They're not like the court system or courthouses that you see today. It's very simple, very informal, meaning there's not a lot of paperwork like there is today. And they're basically carbon copies of the English system. The United States, these people have not made dramatic changes yet to the court system. There's usually just one judge, and that judge is usually a person of great power and prestige, usually very wealthy, and they're kind of the father of the town. And so when people have issues or when they have conflicts for one another, they come into the courthouse, they argue their case, and then the judge decides. A lot of times, judges are reading what were called treatises, meaning they're books about ancient law, books about medieval law, and books about English law, and they're drawing principles out of those books. So little stories or parables or, like for kids kind of thing. When you think about what's the moral of the story, that's what the judges are usually trying to apply. And mostly this is about like domestic life, so whether people can get divorced, whether a woman should be able to have an abortion, which at that time was not surgical, right? It was using herbal remedies. Whether children can be sold to other people. I mean, all these things are about your social everyday activities of the life at the time, but largely most about economic issues, which can be kind of funny at times, like whether your fence needs to be 6 feet high or 3 feet high if you have sheep. And then they could be very serious, as in what to do with runaway slaves. And so this is the place where those discussions would occur. And sometimes they're very controversial, and other times they're the fence size about sheep, as you can imagine, is a very boring conversation, unless of course you're into sheep. At this time, there aren't any national courts. There's no Supreme Court. There's no federal court system. So as the Constitution is being debated from 1776 up until 1802, a lot of people are concerned, especially the Democrats, or the blue color here. They're concerned that the court system will be used to ban slavery. And so they're resisting a federal court system. And so when Congress passes the Judiciary Act, there's some confusion as to what its relationship is with the Constitution, because they're drafting the legislation at the same time people are debating the Constitution. And so one of the Federalist Papers, Alexander Hamilton, who ends up getting shot by the member of the other party, Aaron Burr, Hamilton shoots Burr, but in Federalist Paper number 22, he's arguing why there needs to be a national judiciary. And so this is like, you have to think about this as the courts are just not clear. And these three readings are going to give you kind of the historical legacy up to how it works today. So I just want to stop there and see if anybody has any questions or comments about the history and the geography and the visualization of the court. Or should I move on?
I have nothing in mind at the moment.
Okay. So you'll all let me know if something jumps into your head. Okay.
I have a question.
Okay,
sorry.
go ahead. Yeah.
This was early 1800s?
You could think about this as early 1800s up to about the 1860s, so up to the Civil War. And you could go back as far as the 1600s. So kind of the 1600s to the 1860s, this is kind of a similar mess.
Okay, thank you.
It's a pretty big chunk of time, yeah. So I have to address the myth of anarchy and the origins of rule of law, because the story that tends to be told is somehow that, like, law was something you searched for, you found it, you brought it back to your town. Maybe they were on stone tablets. You got on top of a hill and then you told everybody what the law was, and humans, scratched their heads and said, oh, what a great idea, let's follow some rules. This is insane, right? This is not what happens. So law does not come before human beings creating rules. Humans have been creating rules for thousands of years. And so laws are, a development of whatever that social group, whatever that community wants it to be. And so they vary widely, right? So depending on what the customs are, the practices, the religious beliefs, right? The beliefs about family, that's what's going to determine what the law will become, right? So humans come before the law, not the other way around. So within the origins of the rule of law in the United States, and really England also, historically, from about 900 to about 1300, the concept of anarchy didn't mean the purge. It didn't mean people going around shooting each other. What it meant was that a dictator would be uncontrolled. In other words, a king would be crazy, they'd have mental health issues, and they'd suddenly take over, right, the whole world. And this was the big fear that largely rich elites had, people who owned property, they were barons, they had lots of slaves working for them. They didn't want to be, it was too unpredictable to have a dictator that would just start doing a bunch of crazy stuff, like invade a country because they wouldn't let somebody's sister marry somebody's brother, right? And so they came up with a contract called the Magna Carta, that was a agreement between the king and the representative of these rich elites. And the agreement was, look, we're going to kill you, we're going to go to war, unless you agree to these terms. And if you agree to these terms, then we won't go to war with you. And so law just becomes war using money as opposed to using violence. And so it doesn't stop. You're not getting a refuge from chaos and anarchy. The dictator still exists. There's still violence and chaos going on. It's not a refuge from that. It's just, we're going to try to settle this chaos, or we're going to try to manage it through law instead of violence, right? So law really, in this case, means a contract that's going to try to deal with money, right? So if the king does something bad, then they're going to, like they're doing to Vladimir Putin right now, they're going to charge the country money, right? So they're going to try to avoid war by using money, and law are the rules about what the king can do, what the dictator can't do, what's the red line, what are the consequences, right? So this is the origin of law. It doesn't protect you from anarchy. Anarchy still exists. It's just an agreement not to go to war over anarchy. Instead, you're going to try to use money. So this really obviously should be clear to you. This has nothing to do with poor people. This is about rich people trying to control the economy by controlling the dictator. And this is the legacy, this is the history of, Rome, Greece, Persia, England, the Vikings, right? Germany, France, right? So this happens over and over and over again. So we shouldn't be surprised it's happening in Russia today. And so this is just the origin of what the rule of law is trying to control a dictator or a powerful person from abusing their power. So I'm going to let that sink in as we go to Marbury versus Madison then. So I want to just, again, like, I want to attack, destroy, do whatever I can to get the myth of progress out of your head, right? So there's been technological progress. So for example, people have much better, nicer, more destructive guns than they did in 1800. As you see a duel to the death, this is not a joke, it's not a cartoon, this is real. So right now Republicans and Democrats, just talk about hurting each other. At this time, they literally hurt each other. And so in the sense of like technology, there's been progress, but there hasn't been any progress in social issues, right? Society is not any different. The numbers are different maybe. So, there's not 100 dictators invading Eastern Europe. There's just one right now. But, at the time of this case, Napoleon is invading Eastern Europe. There's a Black Lives Matter movement called the Abolitionists. There's a Police Lives Matter movement called Slave Patrols. There's one political party accusing the other of a stolen election. Women's rights are being restricted based on the needs of women to have children. So the argument in the courts are like, yes, women, you have rights, but we need you to have children, so, you can't get abortions, you can't know anything about chemistry, you can't go talk to other women, you can't have education. And so education here is not equal among the rich and the poor. So all of the things that are going on today, all of the things that are in the news, were also going on in 1800 in the news there too. So things haven't really changed at all. And so that's another kind of myth I want to get rid of, so that we understand when we're dealing with Marbury versus Madison, first and foremost, this case is about slaveholders. All of them are slaveholders. And whether that this individual should be able to be a police officer who goes and tracks down runaway slaves. And so before I get to that kind of micro level, I just want to introduce you to what should have happened in this case. So this case is famous for this Justice John Marshall inventing this thing called judicial review. The cartoon kind of explains it, I think, pretty clearly in a funny way. But let's just go through the details real quick. And this might be hard to pick up in the case because Marshall, to be blunt, is lying and makes it very complicated, and it's not complicated at all. So Marbury is wrongfully fired, right? So you think about it in present times. I go to your job and I say, you know what? You technically were never hired. So I'm sorry, you're not going to get paid anymore. Don't bother showing up. And you say, well, why am I being fired? And I go, I don't really like your political choices. I went to your Instagram, I went to your Facebook, and I went to your TikTok, and I saw all these things you're posting, and so I don't really want you to work here anymore, so I'm firing you. So anybody you ask today would be like, you can't do that, right? I can go to the court and I can sue you and I can call that wrongful termination. So that's exactly what happens here in this case. So the job that Marbury wants is called a justice of the peace, which at that time is a police officers. But police officers at this time are, 65% of their job is chasing down runaway slaves. So enslaved Africans, enslaved Irish people, enslaved American Indians, enslaved French people, when they run away from their plantations, these people, these police officers, are hired by the city to go track them down. Now, ordinarily, somebody like Marbury would hire like 3 or 4 other people to go do the job for him and pay them a piece of the money, right? And there's like some decent country western movies about this. But the other job that they did was maintaining public order. So this would be like if people get too drunk, right? They'd put them in the drunk jail overnight. They try to regulate prostitution, but you can imagine how that probably went, right? They use the prostitutes, but other people don't get to use them. So this is a powerful position, but it's like, it's like a middle manager position, right? So you're not the most powerful person in the town, but you're like the police officer. You're kind of like, it's not exactly the same thing as a sheriff, but this is kind of it's a job that people want because you get good money. And Marbury is a slaveholder, so he basically gets to track down his runaway slaves for free. It's also, you can get favors from other politicians if you capture their runaway slaves, right? So it's just really important to understand, why Marbury wants this job, and to understand that he's wrongfully fired from this job. Yes, but so I'm looking at Karen's question. So were there other slaves in the United States besides Africans? Yes, but like 90% of the slaves at this time in 1800 are enslaved Africans. Now, they'd been being enslaved for 100 years, and so by this time these are slaves that have been bred, and they're coming largely from the Caribbean and from Virginia and North Carolina, and so these are third or fourth generation enslaved Africans at this point. But during the 1800s, you're also having criminals from England who are basically Irish people, so they're criminals because they're Irish, meaning that there's discrimination going on in Britain. And so if you're Irish or you're Scottish or you're Dutch, if you get captured like on a boat, you automatically become a criminal, basically because you're undocumented. And so then they're sent to the United States as slaves. Now, there's a difference. Those slaves would usually work for 5 years, and then they'd be given land. And so they're slaves for 5 years, but then they're free after that term of service. This is also, at this time, there's more people that are starting to capture American Indians and having them work. This is largely in Virginia, to have them work for tobacco on tobacco farms, because Indians have a knowledge of how to grow the tobacco plant, so they're being forced to work there as well. But Indians were resisting and fighting back, so there's a lot of war. That was that kind of earlier picture I showed you of the territories. There's constant war going on between the French, who are also capturing Africans and Indians, the Spanish, who are also capturing Africans and Latin American Indians at this time. And so there's this kind of, there's a lot of war, basically, to put it in clearer terms. But so there's economic, right? So economically, Africans are being enslaved. Others are being enslaved through war, through what we call piracy, right? But don't think about it like Pirates of the Caribbean, right? It's just people are transporting goods on ships, and so it was pretty easy to steal cargo from ships, right? So that's how you're kind of seeing all of this. So as you can see, there's a lot of money to be made as a police officer who catches runaway slaves. So this is a prestigious job to have if you want to increase your political career. And so, you might be able to get more power through this job. It's not going to be easy, but you might. So on the basic level, it's like nobody disagrees in this case that he's discriminated against because of his political party. He's a Federalist, and Madison and Jefferson are Republicans, and so they don't want him to have this job, along with a bunch of other people. Now, he has to bring his case to the Supreme Court according to the Constitution, because here's the Constitution in the orange box, Article 3, Section 2, Paragraph 2. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Original jurisdiction means it's the court of first impression. So you must file your claim there if you're a public minister and a consul. A public officer, like the Justice of the Peace, is a public minister and a consul. It'd be the same thing if you were the Secretary of State or Secretary of Education or any other job, right? That's a government job. So he has no choice. He has to bring his case. He files his case in the Supreme Court, and if he was a regular person, right? Let's just say he's like a merchant who wants to bring a case against somebody else, then he'd bring it to a district court. Then if he loses that, it would go to the appellate court. And then, as it says here in the Constitution, if he's still appealing either law or fact, then he goes to the Supreme Court on appeal. But there's also this clause here in the Constitution that says, unless, under the exceptions, Congress can make particular exceptions. So a very famous exception, at least it's famous among nerd constitutional lawyers like me, is terrorism cases and the right to habeas corpus, right? So if you're captured in Afghanistan and then you're transferred to Guantanamo Bay or to a naval yard in Virginia, you can appeal directly to the Supreme Court to have a trial. That's because Congress made that exception, right? So, in other words, if we look at this situation now, we look at the Constitution, then we look over the case, it is obvious that Marbury is in the right place. He's supposed to be in the Supreme Court. Now, at the court trial, Marshall's brother, Justice Marshall's brother, works for the office that is supposed to deliver these commissions, which a commission is just a piece of paper. Basically, it's a contract saying, like, this is how much you get paid, where you show up, etc. And he testifies, he says that he delivered it to Marbury. Now, there's some people say that he never did that, so that would be perjury. But you should already see the bigger issue here, is that Chief Justice Marshall should not be the judge in a case where his brother is providing the evidence, right? That's a clear conflict of interest. So we already have a huge problem here. And we also have this law, right, a congressional law called the Judiciary Act of 1789 that says that the Supreme Court can issue writs of mandamus. As you're going to see in the next slide, a mandamus is just an order. It's a piece of paper that judges sign that say, hey, Attorney General, you must do this thing. You must certify the election. You must make sure that the kids go back to their parents, right, in a custody case, right? It's just a piece of paper. It's fancy Latin word, but it's just a piece of paper. But Congress said that the Supreme Court can do this. So it's obvious in the textbook, it should be the Supreme Court ruled that Marbury is entitled to his job. Thomas Jefferson and James Madison and the Republicans broke the law and they violated the Constitution. That should be the end of the story. This should not be an important quote-unquote landmark case. Nobody should have read this case. It wouldn't be important because it's really boring, but that's not what happened. So what happened is Marshall lies. And Marshall's very clever in the way he lies. And he doesn't want to anger the president, Thomas Jefferson, and James Madison for violating the law because he doesn't want them to impeach him and the other judges and replace them with new judges. So Marshall makes up this argument, which some people say is genius, that sure, you can look at the orange box and you can read it that way, but I'm the Supreme Court judge and I'm going to read it the green box way. So if you notice the two boxes, they don't look totally different, but I highlighted here, he simplifies the difference between original jurisdiction and appellate jurisdiction, meaning whether the Supreme Court should hear the case first or whether a different court should hear the case and then you appeal to the Supreme Court. So the green box is the one you all know. That's the one you were taught before. You see these like really silly, graphics that say here's the trial court, here's the appeals court, here's the Supreme Court, and it's all based on this lie that Marshall made up. That is not the system that the Constitution set up. It's not the system that the Judiciary Act set up. It's not the system that Congress wanted, and it's not even close to what the British system was. So he argues basically that this piece of paper, I'm sorry, Congress, I know you want us to write this piece of paper, but according to the Constitution, I can't write this piece of paper. And he says the reason I can't do it is because I only have appellate jurisdiction in this case. Now, it's crazy because here's a federal law right here that says, it's these fancy numbers, it's just US code, right? This is where you can find it if you look it up. That cases in the courts of appeals may be reviewed by the Supreme Court by a writ of cert, which we're going to talk about again later. And as justices have repeatedly held in a case, just because it can do that, it doesn't mean it must do that. So just because the Supreme Court can appeal cases, it can also hear cases on the first trial. So they say, but we have had this power for a very long time to decide a case before the courts of appeals have had an opportunity to do so. So what Marshall does here is he turns a can into a must. So the Supreme Court can have appellate jurisdiction in a case like a writ of mandamus, but they don't have to, but he just decides to interpret it that way as a must. So he's violating the congressional law by his own interpretation. There's also another federal law, the Writs Act, which explicitly says that the Supreme Court can issue a writ of mandamus, which is an order to a government official, including other judges, that they must take an action or they're not allowed to take an action. So, I put W2F here because, what planet is Marshall on when he's making this interpretation? It's not based in the common law. It's not based in the Constitution. It's not based in the congressional law. So, in other words, he's just making up a law by making up a power. So he's saying, I just disagree with the way you all are reading the case, or the law. So I'm going to read the law, and I'm going to say it violates the Constitution. Well, this is interesting, and he famously says in the case, we must never forget this is a constitution we're expounding. It's a lovely, lovely phrase, but it's so ridiculous. I mean, why does it matter that it's a constitution you're reading as opposed to some other document? Well, what Marshall is saying, he's like, well, as the court, we have a special power, and our special power is we get to tell you what the Constitution really means. So I'm sorry, Congress, when you wrote the Constitution, you thought it meant this, but, we're basically smarter than you as judges, and so we get to tell you what it really means. And so with this power, suddenly the Supreme Court gets to review all national and local laws, every single act of Congress, everything the White House does, everything government agencies do, from the FBI to the CIA to the Department of Justice to Border Security, anything they do, and then anything any other judge does. I mean, this is an enormous power that Marshall has just given himself and given to the courts. And so he basically just took this power to say that, Congress just doesn't have the authority to give courts a remedy to Marbury. So he just takes the power away from Congress in order for Marbury to get his rightful day in court. So we have to take a second. You all kind of knew this image on the right, even if you hadn't learned it particularly, right? But you knew this thing called judicial review. You knew that the courts had this power. But what you didn't know is that this power shouldn't exist. And so the English system is the one that the United States copied. So this is what separation of powers, which they don't call it separation, they call it fusion, is that the top of this pyramid is not the courts, it's the legislature. And you learned that in your American government, that Congress is important, they pass the laws, they make the laws, the legislature is super important, they're the representatives of the people. So of course they're at the top. They share that power with the Queen's government, with the executive. And so the executive, the president, and the Congress are equal. They share power, they negotiate, and they're ruled by one party. Whichever party wins the election, they take both branches. They have the executive and the legislature. So they don't have these bickering that we have in the United States. Then below that are the agencies and the courts. So the courts don't have the power in England or any of the European countries to review national and local laws, Congress, White House, government agencies, and judicial error. They don't have that power. It's a power that only the United States has ever invented. And so what you would ask, so what do those courts do in England and those other countries? All they do is that, let's say in this case, right, going back to Marbury versus Madison, let's say that Marshall's brother didn't do his job, which I think everybody assumes is correct. Marshall, maybe he was too drunk one day and he just didn't go deliver the piece of paper. So they would look at the Constitution, they would look at what Marshall did, and they'd say, Marbury's entitled to his job, because the law says that he's entitled to his job. And then that's it. They just look to see, did the administrator do the thing that they're supposed to do in the Constitution? If they did it, the person wins, or the person loses. If they didn't do it, the person wins. The other thing would be, did the administration agency go too far, right? So maybe they were supposed to take $500,000 from some rich person who didn't pay their taxes. Maybe they decided that they were justified on penalties and interest to take $625,000. The courts would look at the law and they'd say, what are they allowed to do? Were they allowed to take $625,000, or were they supposed to take $500,000? So that's what the alternative reality would look like if Justice Marshall didn't invent this new power. The courts wouldn't have this power to overrule all of the other branches. And this matters because courts are not elected. So in all of these cases, they're getting to overrule what the elected officials, democracy, has decided is the law. So this is a very anti-democratic, very pro-republic concept. It's courts keep the system very stable and conservative and old-fashioned. They're always looking to stop change in the court system. Are there any questions on that before I go to the next slide? I've been talking a while. All right, so nobody's raising their hand, so I provided Federalist Paper 47 so that you could get into this a little bit more carefully. I know this is not like a super exciting reading, but it's super important. So if you haven't read it yet, I encourage you, even if you haven't got the book yet, please try to get the book as soon as possible. You're going to need this information after spring break in particular. So you still have time if you haven't got the book. If you have the book, go back and read Federalist Paper 47 again very carefully. I want to give you a little bit of background, so maybe it makes it a little bit easier to reread the reading. So part of this idea in the Middle Ages and what was called the Enlightenment Revolution is that men, and sorry everyone else, like it's only men at this time, who have property, meaning in order to have property in 1685, you got it two ways. You either killed the people who were living on it and then took their property, so now you have property, or it was given to you by your ancestors. So those were the two ways that men could have property. The argument that was in the writings that people were writing during the Enlightenment was that if I have property and I'm a man, I shouldn't give up my individual liberty. In other words, if the king or anyone else wants me to do something, they should come to my property and try to kill me, and I have the right to defend my property and I can kill them. We still have this principle in the law of right to self-defense, no trespassing, right? All these principles still exist today. And it's all based on this Enlightenment, where people said, why are we listening to the church? Why are we listening to the king? If they want my money or they want my land, let's see them come and try and take it. And the argument for this at this time is a very religious argument. And they're arguing, doesn't matter what the Catholic Church is saying in the 1600s, doesn't matter what the Church of England is saying, every man is responsible for his own soul. So if you want to go to heaven, you can't listen to the Pope, you can't listen to the king, you're going to have to make these decisions on your own. And so this is the idea of property holding men are responsible humans, and so they have to fight for their liberty. So if you have to be under a rule of law, and this is very important, all these kind of boring old dead white men, John Locke and others are arguing, like if you have to do it, then you have to make this contract between the king and the rich, and you have to make a trade. So they're going to give you something, and you're going to give them something. So the something for something here is that if I'm going to give you money, rent, then you have to protect me if the French try to come and invade the country, or if the Vikings come in and try to invade the country. You have to protect me. So I'm going to give you taxes, and you're going to establish what are called knights, which are soldiers that are going to protect the country from outsiders. And that's the negotiation that we're going to have. If you misuse those soldiers, then now I have the right to get my own soldiers and overthrow you and cut off your head. And this happens several times in English and French history. The worry at this time, so philosophers were looking at this exchange, and they said, what I'm really worried about here is what if a small group of rich elite people take all the power? So the government, the king has the power of the judiciary, the courts, of making laws, and of the police. But what if a small group of rich people take those powers from the king? What are we going to do? How are we going to protect our property from those rich elites? So this worry by people like Montesquieu and these other philosophers at the time has become reality today. So for example, the very thing they were worried about is what actually exists now in America. So less than 2% of Congress held any working class jobs. They don't have any idea what it's like to be me and you. So they hold the power of legislation. They're rich. All of the Supreme Court justices went to elite, expensive law schools. So the courts are all occupied by rich people that have no idea what it's like to be you and me. And at least each of the last 6 presidents went to Ivy League schools. So the administrator, the executive, the police, they're also run by these rich elites. So the social contract theory is BS. It didn't work. So there has been no consequence for the misuse of power in the United States yet, right? So keep that in mind as people on the left, liberals, and people on the right, conservatives, keep arguing for overthrowing the government and that it's not legitimate in representing them. We don't have to agree with them that they should use violence. I might disagree with some of you on that. Maybe at some point you do have to use violence. But the argument that they're not represented on all 3 powers is correct. They are the exact fear that they had during the Enlightenment is the exact same going on. And Federalist 47 is really talking about why the Constitution as it's written is supposed to keep this from happening. So the first thing is that Madison explains very clearly that this thing that some teacher told you in the past isn't real. There's no such thing as separation of powers. It's a ridiculous concept, and it's never been done. And so he says very clearly on page 107, if you look at each state, so you look at Virginia, you look at New York, you look at New Jersey, there's no issue where there's all 3 powers are separated. They're shared. And so they've never been separate and distinct. So he's kind of venting in that section of the reading, saying, I don't know why people believe this is real when it's not real. So he says, in theory, it would be lovely if you could keep all 3 branches separate. But that's not reality. They're all connected to the same tree. And so it's just a silly concept that doesn't have any reality. So he argues that a blending of powers, though, that's more realistic. And so the goal here would be to check absolute power. So if you have a blending of powers of the courts, the cops, and the legislature of making laws, then you should be able to check the power against the rich. That the rich shouldn't be able to have, abuse of power against the poor and the working class. So Madison is really happy in Marbury versus Madison, and yes, right, the same person who writes Federalist 47 is the person who's being sued in Marbury versus Madison. He's happy that the Supreme Court decided not to check the power of the president, okay, so did not separate the powers, but blended it instead and said there's a rational federal cooperation here where the Supreme Court is working with the executive and really to argue that Congress overstepped its bounds, that it abused its power. So here you see the Federalists are basically making an argument with the Republicans that the federal court system should basically not be involved in politics. And so that's how checks and balances works out, and that separation of powers is not real. So I'm going to check there. I just want to check in there because then the last one is what does that have to do with today? So I'll just move on unless anybody has a question. I'll look for your hands in the chat. So what this has to do with today is, let me remind you again, right? So the world is chaotic, it's anarchy, right? There's nothing you can do about that. That's just the way the world works. Everybody is born, everybody dies, and it's anarchy in between. That's basic science. So what do lawyers and judges try to do? Well, this might not be a very effective strategy, but what we do is we read and read and read and read, and we write and write and write and write. So we read and write, right? Things that you learn in elementary school and in college, right? You just do it more and you do it better, and this is what lawyers do. And this helps you think. And so this is, they're reading history, they're reading current events, they're reading as much as they can, and then they're writing opinions about this, because remember, law is war by other means, right? So it's trying to resolve things mostly through the economy and through trying to make contracts with each other. The practical thing that a clerk does, so people who work for the judges, right, so they're called judicial clerks, and this is in the modern clerkship reading, is they review what's called the cert pool. So cert is like a ridiculous Latin name again, but what this means is just certificate, right? So when you bring a case to the Supreme Court, there's literally a little certificate, and the court is either going to stamp that they're going to hear it, or they're going to stamp that they're not going to hear it. So here's one big pet peeve I have about the media. So you'll read like a story in the news that will say, the Supreme Court decided not to hear this case, right? That doesn't mean that they ruled against the case, right? So somebody brings a case, and then the Supreme Court just says, we're not going to hear the case. That doesn't mean that they said your rights are valid, or that what happened to you was unjust. They're literally saying nothing. And remember, this is all tied back to Marbury versus Madison. They have the right to basically decide which cases they think are important and which cases they think are not. And just to make this super clear, in the cert pool, in the total number of cases that end up to the Supreme Court, very few of them get to the Supreme Court. So most of the cases are, stamped no, we're not going to hear this case. So the clerks review those, and they put them into categories, basically saying, this is a criminal case, this is an administrative case, this is a prisoner case. Then they have like a plus minus system, right, where they think this is a case that's important, this case is not important. The judges then look at the cases based on those categories. So that's one thing clerks do. The other thing is that they make these briefs. And so there's legal briefs where you write about what you think the law is, what you think the arguments are going to be, who you think should win. And they write notes in the columns, and that's called annotation. So they say, if you're interested in this, go see this other case. Think about this legal principle. They also write memos for judges. So they basically write the judges a letter saying, this is what I think you should do in this case. And oftentimes they're asked by the judges to write a draft opinion. So when you read a Supreme Court case decision, it likely was drafted by a clerk, right? Somebody who works for the judges, not the clerks themselves. Now, as you read in the reading, Justice Ginsburg likes to write her own cases. Justice Scalia likes to write his own cases. But, lots of other judges, they have the clerks write the cases first, and then they make minor changes. But some judges don't want the clerks writing their cases at all. Now, just to kind of wrap this up, writing an opinion then, in this case, that's right, quote unquote right, just means that you're correctly analyzing the law and that you're analyzing opposing points of view, meaning you're making your right argument, right? You're not saying that this is the truth, you're just saying this is what you think based on your interpretation and reading of the law. Now, moving to the right-hand side, we got this problem, right, that we have to confront. So this is also not a joke. This is a real picture of a bunch of white men in a line and a couple white ladies. So the clerks who work for the judges are overwhelmingly white men. And so you see this real racial and gender problem. And then it's also a class issue. Most of them went to these prestigious institutions. So these people are totally disconnected from everyday people. And it's very biased, obviously. Now, the other problem is that, as you see, right, active attorneys, 64% of them are men, and most of those men are white. And so there basically just needs to be more people from diverse backgrounds, especially African American, Latina, and Asian, and especially multiracial, that are going to law schools, right? But that means you have to go to law schools that you can afford, right? So that's another dilemma. And so these are just kind of systemic problems that basically make clerks predominantly white men from rich backgrounds. That's what makes Justice Ginsburg a bit different. This is an interesting question, right, Jocelyn? I mean, you tell me, like, what do you need to do in order to be a judicial clerk for the Supreme Court? Like, somebody tell me what you have to do.
I mean, so far you explained you have to be a male, I guess, because that's mostly what's there, and obviously come from, these expensive schools. But I mean, anything's possible. Like, I mean, I don't want to sound corny, but like, I'm sure there's people who, can, like, my English professor used to say to me, like, be yourself, like, to the max. Like, don't, like, try to hide yourself, your personality, because, that's going to help you, like, get further in life and all this other stuff. So I feel like it's possible, but like,
The issue is this, right? So I would say don't think about being a clerk. I would attack the bottom box. Go to law school, right? That's the first hurdle. You're not going to have any chance of being a judicial clerk unless you go to law school. And so the more women of color who go to law school, the more women of color who will end up being clerks, and the more women of color who will be judges, right? So, but hurdle number one is graduating community college, then graduating transfer college, then graduating law school. So law school is like, that's the place where the most change can happen. But kind of getting to your point, like anything is possible. So one criticism of criminal justice students in particular is that you're all really bad at math. And I want to help you be a little bit better at math. You know, if you look at these percentages, if you want to be a judicial clerk, not only did you have to be better at picking your parents and picking your gender, you had, which is impossible, right? I'm being funny. You also had to make sure you go to these schools. Okay, so here's the dilemma. I don't know how many of you play the numbers, right? But let's say you're gonna play the lottery. Okay, so the difference is that the lotto right now, if you want to go play the lotto, let's say you're gonna pay $1 or $5 or $10 or even $20. Okay, so what are your chances of winning the lottery? Right? Not good. But what we're asking you here, based on your question, how hard is it to become a Supreme Clerk? Look at those numbers. Those add up to almost 100%. I mean, you have like 0 chance of becoming a clerk right now unless things change dramatically. So and we're asking you to pay $200,000, sometimes $300,000 to go to law school. So we're saying we want you to bet $300,000 on a like 2% chance that you're going to become a judicial clerk.
right.
So if you feel fine getting a loan for $300,000 and going to your local bodega and putting all that money on Moneyball one time, then go for it. But I'll tell you, you're going to be surrounded by people who don't make those decisions. So you'll be the only one.
Oh man.
So I'm setting you up here. I'm setting you up not to be depressed. I'm setting you up to understand why people like Justice Ginsburg worked so hard to try to change the system,
Right.
so that you don't have to make that ridiculous choice. So here's one quote from the reading where she says, you know, one thing she does is she tries to avoid arrogant law students who are coming from wealthy, privileged backgrounds who don't seem to have a clue. So she doesn't hire those people. So that's step one, right? So that tells you something. That means the other judges are hiring arrogant, privileged brats, right? So she's taking stand one is, I'm not going to hire those people. I'm going to make them actually, you know, work. And the thing that she called like a foul is, don't treat my secretaries poorly, right? Be nice and be a good person, be a decent human, and then I'll hire you as a clerk. The other thing she says is like, you know, it ain't, and I love you know, she's not using quote unquote standard English here, right? She says it ain't necessarily so. So she's talking like a real person. You know, she says there needs to be a good relationship between the justice and the clerk. So they have to really talk about kind of the questions that you're bringing up. And so she looks for people where it's not just going to be, you're just going to write an opinion and I'm going to agree with you. She's looking for people who come from different backgrounds. So in the reading, she hires people that don't necessarily come from the same background as her, who don't share the same opinions as her. She thinks that's an important thing to like get all the judges to think about. Because what do you think happens with most of the white privileged men? They hire little carbon copies of themselves that were probably exactly the same kind of person, you know, they were when they were in law school. And so she's trying to break that trend. She's trying to get judges to hire people who are different from them. That would be a huge change if they just did that. And then the other thing she talks about is she tries to talk in plain language in a way that lots and lots of different people can understand, so that the court isn't so elite, right? That it's more kind of grounded in rationality. Okay, so finally, just wrapping up then, to kind of understand how it goes from the origins to today, is just remember, most cases in the federal court system, they're not criminal cases. So just get this out of your mind, right? The other thing is, sadly, it's very hard and expensive to bring a civil claim in court. And so this is a place for the rich, right? Federal courts are the playground of rich people. And those criminal justice cases that do end up in the courts, these are large corporate law firms that are, bringing cases on behalf of like 100 prisoners who they think are being treated unfairly, because they're going to win a huge award, and then the lawyers are going to take 30% of that award. So they're going to get $100 million reward from winning a case. And so, again, this is the playground for the rich. If you're lucky to be an abused prisoner, you might get something out of that. But it's a very, I'll be blunt, it's a corrupt system. State and local courts are the ones that have much more contact with everyday people. The problem is, if you look over here, you have to bring constitutional or federal cases in the federal court system. And so this is like one of those rare arguments where this is where you should get more involved with like community boards, city council, just to get them to enact laws that are the same protections as constitutional rights or federal laws, right? And to get state and local courts to actually hear cases that are rights-based cases, you have to advocate and get the laws to change to protect people. And so this is the big disconnect I think a lot of students have, is that you think you have constitutional rights, but to be blunt, you're kind of like Marbury. You can't really win. So you have them, but the courts aren't going to actually implement them. And then the final piece of this, which we'll probably get into later in the semester, is rights differ based on what jurisdiction you're in. So the other thing that the Federal Judiciary Act did is that it established this system where you've got Supreme Court, circuit courts, and district courts, and then the separate court of Washington, D.C., which is kind of funny. But it also divided, there's circuit courts across the country, and the 9th district is the one that's considered the most protective of rights, whereas the 11th district is like, good luck. 11 and 5, like, you're basically rarely going to win for rights cases. And those are the, 11 and 5 down here on the bottom, those are the places that restrict abortion, they are pro-death penalty, right? So 2 and 9 are anti-death penalty, they, are more predictive of women's reproductive rights. And so there's this mixture. So it's not consistent across the entire country. And so I just want to put that into context, and now you kind of see what are the bones of the legal system, how it's biased, why it's biased, and some of the problems that kind of come from that. And hopefully I've corrected some legal myths that you learned along the way. Now you know what the reality is, and that hopefully will set you up for after spring break when we start looking at kind of